Saturday afternoon, morning, evening, depending upon where you are in the city. Welcome to From the Halls of Justice. My partner and colleague and associate producer here, Murvet Arnstein. Hello. Happy holidays. We are going to bring you an outstanding show today. The topic of this show, it's going to be complicated breakups, and you are going to really enjoy this. You're going to learn a lot. We have two very distinguished guests in the studio today. I am honored and humbled and pleased to have with us Mr. Greg Barchie, and Mr. Barchie is with the law firm of Rubin, Rauscher, and Blum. We have a picture of the three partners, and if we can go to that. And the interesting thing about Rubin, Rauscher, and Blum is that Mr. Rubin is the senior partner. He's the gentleman in the center, and Miss Blum, the beautiful woman, is his wife. Mr. Rauscher, can we go to the next photo? Was the president of the Beverly Hills Bar Association, and we are just so pleased and humbled to have Mr. Greg Barchie, who is representing this firm, in the house today. So, Mr. Barchie, thank you so much for being here.
Thank you for having me.
Our other guest, and it's going to be a two-part show. We're going to open up with Mr. Barchie, but the other person in the studio with us is Mr. David Shebby. Now, Mr. Shebby is with the firm of Jacobson, Scully, and Shebby.
That's right.
So he is a partner at his firm, and you're going to learn more about him. We're going to start off with Mr. Barchie, who's going to tell us about unfair competitions, and then we're going to end up with domestic violence with Mr. Shebby. So sit tight and grab your coffee or your tea, and let's open up the show. And I'm going to start off once again with Mr. Barchie with unfair competition. They say that an employee has been working for one company for a long time, and let's say that the employee wants to use the skill that he or she has obtained from the employment to start a competing business. Okay, is the employee permitted to do this?
Yes, in California, actually, any employee has a right to engage in fair competition. The key word is, of course, fair competition, being that the subject of this particular this show is unfair competition.
Okay.
There are restrictions in terms of what they can do in terms of preparing for the establishment of that competing business or enterprise or whatever they may be doing that would be actually competing with their current employer. For instance, they are allowed to announce to, let's say they work in they could work at a law firm, for example. They can announce to the firm's clients that they are changing their employment, but they're not actually allowed to solicit those clients for the future employer, because that would be actually unfair competition. They actually still owe a duty to the employer, and in fact they're not to, they have a duty to actually not cause harm to that employer. So basically you're not allowed to poach those clients for the new employer.
What if the clients want to go with the other attorney?
Well, that's a good point. There's a difference between announcing that you're going to be leaving your current employer versus solicitation. You're sort of more restricted about what you can say to the client than what the client can say to you. The client also has a right to go wherever he or she wants to go.
Okay.
However, as the employee, you have to remember you still have that duty to your employer to not cause harm to that employer. And so it would be unfair for you to say to the employer, to the client, that I am leaving the firm, I'm going to this new firm, and that new firm is great, and you should jump ship and come with us. Just saying, though, that I'm leaving the firm, and if the client says, oh, well, I'm only at this firm because of you,
right,
I'm going wherever you go, that's fine, so long as you don't actually push them in that direction. Now, when I say you can't push them in that direction, my advice would be, don't say anything that would encourage them to go anywhere. You can merely, again, you are permitted to say that I'm going to this new employer, but do not under any circumstances, invite them to, say, we got this great company that's starting up, and I invite you to come talk to me about whatever you want. Even though that may sound innocent, in reality, that's considered solicitation. Really, if you're going to discuss your future employment, make it only an announcement about what your plans are, and leave it at that. If the client decides to go with you because of that announcement alone, you're okay. But otherwise, just don't solicit or don't invite that client to follow you to the next job.
Okay. Because I was going to say, that's the other situation, though. I must tell you that a lot of people are relationship oriented. And basically, if that client has bonded with their attorney, if you're out the door, more than likely they want to go with you. So
they might, but there could be a variety of reasons. No, this isn't restricted to law firms, of course. There are obviously accountants have clients, property managers have clients. There are a variety of business that have client relationships.
Right.
And largely, for that matter, it comes down to even vendors. For that matter, if you talk to a vendor, say, "Hey, I'm going to this new company. You should follow me over there." That itself could be unfair competition, because you are essentially causing harm to your employer if the vendor decides not to do business with the current employer because they're going to jump ship to the new employer.
Right.
So it's not restricted to clients. But in any event, so I just wanted to make that point. But you're right, it is very relationship oriented. Right. So you should just allow, make the announcement and allow the relationship to do its work.
Right.
There could be a variety of reasons why the client, even though, say you were the one that actually brought that client into the business, you are not entitled to that client relationship to the new business. Allow the client to make the decision. Your new business could have a smaller staff, or it could have less money. There could be more resources at the current employer than at the new job. And for that reason, the client may decide, you know what, despite the fact that you brought me in, I'm going to stick with with what I've got because of these variety of reasons.
Right.
But really, in the end, the message is, don't push the client to come with you.
Don't solicit.
Don't solicit. Don't invite.
Right. Well, and like I said, relationship is very important, because I won't tell you the name on the air. You can contact me later. I have a Mercedes mechanic that I am never going to leave. I love my mechanic. When I get married, I'm going to have him interview my husband, because that's how much I trust him. So,
but that mechanic is a great I talk about lawyers because I am a lawyer.
Right.
Often lawyers have very sort of narrow focuses on what they do, because we only hang out with lawyers. But mechanics, these rules apply to everybody. Mechanics is exactly just that. If the mechanic called you and said, "Wanda, I'm leaving this particular garage and I'm starting my own garage."
Oh no, he's the owner.
Okay, well, unfortunately this doesn't help us. But let's say it's just merely an employee. The mechanic says, "I'm jumping ship to this new garage and you should come with me." Even that mechanic, the owner of the mechanic's current employer could sue him for unfair competition.
Oh no, if one of his employees did that, I would have to tell them bye-bye, because my owner and my mechanic is the best. He's the bomb, but I won't tell you.
Well, the mechanic should, the point is ultimately for the audience is that the mechanic should just have confidence in his client relationships. And if he moves on, he should just, after he moves, then he can, well, actually, I'm going to stop. I'm not going to say that. But after he moves on, I know, I almost said something incorrect. But after he moves on, he should have confidence in his client relationships. If you voluntarily choose to follow him because you like his service, he's done nothing wrong, and that's how we should leave it.
So this is a good question. What if an employee signed an agreement not to compete with an employer?
Well, in general, those are unenforceable in California.
Really?
Now, I'm not talking, California is a very unique place because covenants, or actually a covenant is more of a legal term, agreements for you not to compete against your current employer or even a prior employer, or even that would be restricted to just a geographic area, are unenforceable in California. Now, this is not true in every state.
That's awesome. I didn't know that.
Right. So this is only about California. So I don't want to make any representations about what exists in law in New York or in Oregon or Texas or any other place.
Call
in fact,
Mr. Barchie, you know.
There are a lot of states that allow those agreements to restrict you from competing against your former employer. However, that does not exist in California. There are a couple of exceptions. the two big ones are, in fact, have to relate to if you're actually an owner in the if you're an owner in the business. In a partnership or a limited liability company, if you are an owner in those particular companies and you are jumping ship, the LLC or the partnership can say you can't do business in this geographic area so long as we are also doing business in that geographic area. But that doesn't actually involve the employee-employer context because you're actually an owner in that particular company. There's also an exception if you own a business and you're selling that business to someone, and that business largely involves goodwill, which of course means client relationships.
Right.
You can't sell your business and then start a new business within that same geographic area and compete against the guy who you just sold all the goodwill to, because
see, that's
California,
a lawyer thing.
That's a lawyer thing, but California recognizes that as being unfair because essentially, what did you sell that person if you're just going to start a competing business across the street and take all that business back?
Excuse me. Time limit where you can't start a business?
In general, no. They can restrict it to it's really geographic area. But this again only involves sort of like ownerships and sales of ownership of business. For employees, really the only restriction is you're not allowed to use your current employer's trade secrets. Now, trade secrets can be a very broad term itself. It could mean customer lists, it could mean the client list, it could mean vendor lists, it could mean any compiled information that the employer put their ingenuity, time, expense, and in compiling. So even though it might be a bunch of information that you can find in the phone book, the compilation of that information itself is a trade secret, and you're not allowed to use that information. The employee is not allowed to use that information to his benefit in the next employment.
Okay.
Can you use a customer list to send announcements?
He can. In fact, he can.
Ooh.
That's a very good distinction. You can, even if it's considered a trade secret, you can announce the trade secret, that list of trade secret clients, the announcement to the next employment. But otherwise, in the next job that you take, you can't use that list to solicit those same clients.
That was a good lawyer question.
I didn't mean to step on your toes.
No, that was good. That was good. Go ahead, Murvet.
Okay, does an employee have a duty to disclose that he or she is preparing to start a competing company?
It depends. If you're an officer of the company, there's a split of opinion in the courts. Some say yes, some say no. You should probably err on the side of yes, you may need to disclose this. If you're an at-will employee, which is most people, an at-will employee is basically that they can fire you for any reason except for certain categories like race, gender, religion, things that we all know about. But most people can be laid off or fired for whatever reason. They don't need good cause to fire you. Those at-will employees don't need to disclose anything, and the policy behind that is, why should the employer get any special treatment? If the employer can fire you for any reason, why shouldn't you be able to jump ship for any reason? And you don't have to disclose those plans to the employer.
Wow. Okay.
Well, so I guess we should go with Mr. Shebby.
All right.
You are going to talk about domestic violence, but before you do, can you tell us about yourself a little bit? How long have you been with the firm?
Sure. We started a current firm, Jacobson, Scully and Shebby, a little over a year ago. My two partners and I are all certified family law specialists, and
all of you?
All the three of us, yes. So we thought, and we had all been friends beforehand, working at different firms, and we thought we'd bring our expertise together. We all kind of specialize in different areas of family law, and start our own practice. We've been doing that for a little over a year.
Great. Okay, my first question is, what is the legal definition of domestic violence?
I'm talking now in the context of the family law. Right. There are different definitions if you're dealing with criminal prosecutions.
Yeah.
In family law, it's pretty much what you would expect. Violence or threats of violence, except for one thing. The fourth definition of domestic violence is exceedingly broad, and it includes disturbing the peace. What does disturbing the peace mean? It means destroying somebody's emotional or mental calm. Now, I don't know about you, but I'm unaware of any relationship, going back to Adam and Eve, where at some point Somebody's mental or emotional calm has not been destroyed in that relationship. I mean, I think effectively under California law, there is domestic violence in every relationship, in every human relationship of substance.
That's true.
The question then becomes, when can courts intervene? When can you get a protective order?
That applies to a lot of people, except for Mr. Barchie, because he's a newlywed.
Yeah.
So he's going to be happy no matter what.
Oh, I can't imagine him disturbing anybody's emotional calm. He's a very nice guy.
Only in my legal profession.
There you go. Exactly.
Not in my marital relationship.
Exactly.
Very good. What can a victim do to stop it from happening again?
Well, if you're a victim of domestic violence, you can get a domestic violence restraining order. And the best way to do that is to get a lawyer. If you can't afford a lawyer, all of the courthouses have clinics that will help you fill out the paperwork. But if you can prove to the judge that you're entitled to one, you can get a restraining order that will keep the abuser, at least orders the abuser from ceasing his or her activities.
So what types of orders are available?
You know, a restraining order can do everything from restrict somebody's conduct, what they can and cannot do, to where they can live. You can have somebody removed from the house. It can restrict them calling and telephoning and contacting in any way. All domestic violence restraining orders include firearms prohibition, and as of next year, ammunition prohibition. So if somebody has firearms or ammunition, they have to turn those over.
Now, I know that there's one of the obstacles in getting restraining orders is the filing fee. Is there a way to get those filing fees waived?
Well, there are no filing fees for domestic violence restraining orders, and that may or may not lead to an abuse of the system in some cases, but they're free.
Okay.
Interpreter services are also free in domestic violence cases. So if you don't speak Spanish, the court will provide an interpreter for you. I'm sorry, if you don't speak English, the court will provide an interpreter for you.
Excellent.
So can you tell us what is the procedure for getting a temporary restraining order and just a restraining order?
Sure. There's two kind of stages to it. The first thing that usually happens is somebody applies for a temporary restraining order. And these are restraining orders of short duration, usually a couple of weeks. You don't even have to give notice to the other side. You just have to go to the court and ask for one. There's a very low burden. All you have to do is show a reasonable need for one, reasonable proof that abuse has happened. A few weeks later, the court will have a full hearing where both sides are present, and you'll come in and you'll put on evidence, and the court will decide if a full restraining order should issue, and that restraining order can issue for up to 5 years.
Wow.
Yeah.
Okay, so how should one prepare for a restraining order? I mean, when you're seeking one, what should you do?
Well, if you're seeking one, the most important thing to do is to show up in court ready to go with all of your evidence. If you have witnesses who have seen the abusive conduct, you got to make sure that they're there. If you have a police report, or if you have any physical evidence, maybe photographs of injuries, you got to make sure you bring them, because the court's going to expect you to be ready to go on that first day. It also helps to remember that even though this is an informal proceeding and a lot of people don't have lawyers, you need to act like you're in court. You need to dress appropriately. You need to conduct yourself appropriately, even if you're not getting along with the other side.
If a restraining order is issued, what will it say, and would the restrained person still be able to see the kids?
Yeah, I mean, we talked a little bit before about what it might say. It might say you have to stay 100 yards away from somebody. It might say you can't contact somebody. For sure, it will say that you must turn in any firearms or ammunition you have.
What just happened then in, okay, I'm sorry, now I'm going off the, what happened in, what was it, not Newport Beach, but Orange County, the crazy guy that just recently, Seal Beach, okay, and I guess the judge, he got upset over the custody order, and he goes into the beauty salon and he blows the staff away. I'm very partial to my hair person too, by the way. So
the beauty salon needs to be a safe place, for sure, right? But you raise an important point. I mean, even if you get a restraining order, it's just a piece of paper. It's just a court order. It won't stop a bullet. It can't make somebody turn in a firearm. It's an order that they do so. They can be punished criminally if they don't do so. But in seeking this relief, you have to make sure you understand that this alone, in the most serious cases, isn't going to be enough to protect you.
Okay, why wouldn't they, if you get the order, you're not supposed to have the firearm. If the person is present in court that day, that moment, have one of those nice big deputies come over, and they got women deputies too, like one-shot Murvet over here, and at that point, seize the weapons. You know, go home with this person maybe. Make them reveal where every concealed weapon might be and take those weapons. Maybe? Huh?
I don't know if the sheriff has enough manpower to do that, but that's certainly something that, you know, right now you're ordered to provide proof that you've turned in the weapons within 24 hours. I don't
think... It's that 24-hour thing that killed those people.
It is.
Yeah.
And beyond that, a lot of people don't do it, and the sheriffs and police departments, at least most of them right now, this isn't a priority for them to follow up on it and see if it's actually happening.
Okay.
You were asking before about the kids. The answer is yes. In most circumstances, unless the court finds it's not in the best interest of the children, you're still going to be able to see the children. Okay. Now, the court might make orders that even allows you to communicate, even if a restraining order is in place, only about the children, if the court thinks that's appropriate.
I just thought of something else too.
Yeah.
I know a lot of people, now professional people, are
Sure.
afraid of restraining orders because if you have a restraining order against you, it could hurt you at your job or at your profession. Some people could actually lose their job.
It could hurt you in a whole variety of ways. And one of the issues that comes up is, should I fight a restraining order? If I'm breaking up with somebody and they want a restraining order that says, don't call me, and the guy says, well, I'm not going to call her, what do I care? He should care. He should still care that a restraining order is being imposed upon him, even if he has no intention of ever calling this woman again. It can affect his employment. We talked about the firearms restrictions. If he's a hunter or he just wants guns for personal protection, it can come up in background checks. It also imposes presumptions with regard to child custody, with regard to support, with regard to attorney's fees. It really has far-reaching effects that some people don't consider when they just say, oh, I don't mind if a restraining order gets entered. I'm not going to call her anyway.
Okay. All right.
You want to be very careful before you decide not to fight a restraining order.
Okay. All right. That's good advice. Okay, I think this was Murvet's, but I'm going to start for her. Are there any concerns that you would have as a lawyer regarding the abuse of the system?
I think that there is. I think anybody who practices a lot of family law sees abuse of restraining orders in the family law system.
Okay.
The legislature has expanded the definition of domestic violence so dramatically, and we talked about that at the beginning, that anything can be domestic violence. And now they've allowed just about every type of relief you can get in a family law action to be granted in a domestic violence proceeding. That includes support, that includes fees, that includes property division in some cases, that includes orders to pay for debts in some cases. And it's done all without a filing fee. Okay. And it's done in a way that puts you at the head of the line. You know, there's tremendous backlogs in the court these days because of the budget situations.
Right.
But anybody who's in court on a domestic violence case gets statutory priority. They get to jump to the head of the line with regard to their child custody issues, their child support issues, everything else. And I think some people do abuse that. Not everybody, but certainly some. Also, if they know there's going to be a contested child custody hearing. One of the first things a lot of people hear from some lawyers is, well, if you can get a finding of domestic violence, that's going to help you with child custody.
Wow.
Completely unethical. People do it all the time.
What are the consequences for violating a restraining order?
It's a criminal act. You can go to jail, you can go to prison for it. And especially when people get domestic violence restraining orders because of a single, not all that serious act. What we see is people reconcile. You know, and there's a restraining order in place, and then they reconcile anyway. And from a human perspective, we understand why that happens, but the restrained person needs to really know that somebody changes her mind and calls 911, you know, he's going to prison, or at least to county jail, for violating a restraining order, whether or not he was invited over.
Right.
So you need to be really careful, even if you get invited.
How long do the orders last?
They can last for up to 5 years on the initial order. However, the restrained person can go back and have them reissued as that 5-year, that initial period expires. And that reissuance can be for another 5 years, or it can be permanently. So we talked earlier about how important it is that somebody not just consent to a restraining order being imposed against him. It's equally important that he doesn't just consent to a renewal being imposed upon him, because that can be a lifetime sentence to this restraining order.
Okay. Well, we've got only a couple of minutes where we're going to have to wrap up the show, but I'm going to have to... Mr. Barchie, thank you so much for correcting me. I didn't want to give Newport Beach a bad rap. It was Seal Beach that this guy
Seal Beach has the bad rap.
Yeah,
okay.
yeah. I think Newport Beach, a tree fell down and crushed the car and killed that chick, so that was bad. No. So Newport Beach, bad trees. Seal Beach, bad guns. So with that being said, I want to thank Mr. Shebby so much for being here, and I got to ask this question because it's going to be a really important one. So, Mr. Barchie, what's it like working for Mr. Rubin?
Well, he's essentially my mentor. He's been my boss ever since I got out of law school. Everything I know, I learned from him. Very good. Yeah, and he's a great attorney. That's the other thing. So, as far as I'm concerned, there's nobody better to learn from.
Awesome, awesome. Mr. Shebby.
Yes.
Certified Family Law Specialist.
That's right.
All three of you.
All three of us by the State Bar of California. We have a young associate who just joined us, and in 5 years, we expect she'll do the same.
Oh, terrific.
Yes.
Well, I want to thank you, gentlemen. We got 1 minute. I want to thank you for being here. I know it's the holiday season. I know you have parties and everything to go to. From Mr. Barchie, we have learned how not to compete. And from Mr. Shebby, we have learned, wow, your stuff is heavy duty. The restraining orders, I would really like to be able to see some more effective I don't know, rallying behind if a restraining order is in place, and if it's necessary.
Sure.
It's unnecessary, but maybe if the sheriffs or deputies could get involved and possibly collect those guns before they leave the courthouse.
It's a resources issue. Nobody wants to pay taxes. We're not going to get that done.
Okay. Well, thank you for being here. Thank you for joining us on From the Halls of Justice. You can go online, and if you have any questions, email us. Pull them up on the website. Thank you so much for being here. It's From the Halls of Justice, and we will see you next week. Happy holiday season. Complicated breakups.